housekeeper. Currently, she's on non-paid leave. However, that's temporary and she could permanently lose her job there. She has 4 kids, and one of them, Ms. Latricia, is the sole provider for her kids. Her family is here today in court as well, and she has a place to stay with them upon release. So we're asking for Ms. Latricia to be released, and she is okay with complying with GPS tether or any other conditions the court finds necessary.
This is a classic pretrial release argument: family support, employment risk, GPS monitoring, but notice the subtext here. The defense is trying to humanize the defendant. Fast 4 kids, sole provider, housing lined up. Question for you: should personal hardship outweigh public safety when the charges are violent?
Responsible.
Well, at this point, I'm going to object. This is an extremely serious case. The victim was attacked with a hammer, and she was hit in the head with that hammer. There was a struggle that led him, and during that struggle, he was then stabbed in his stomach. So given the severity of this case, and the injury that she sustained, I'm going to object.
Your Honor, we are presenting this case as a self-defense, and Ms. Latricia would not be staying at that address upon release. She would be staying with her daughters, looking after her.
Okay, this is where everything shifts: a hammer, multiple head strikes, then a stabbing in bond hearings. Severity is king. And this description is designed to shut the door immediately, even before trial. Judges are thinking risk to the community, and that's a hard bell to unring.
That might factor in the court's decision, but if that's not what's being said, then I'm not sure the true self-defense apply in any of that, although I'm not trying to make that proposal.
There was no actual weapon.
Do this. There's the allegation that there are 2 weapons that would be used by this defendant.
He did have a knife, Your Honor.
Okay. Then you can certainly address that even while factor that in. I still don't think bond would be appropriate, or a reduction in bond would be appropriate in this case. I'm going to deny your request. Certainly you may raise that after the presentation on the 20th before you show. Lady? No, come here. Come here. Oh boy. Get her, Mr. Allen. Who is? Was it?
Family of the last client, I believe, Your Honor.
What? No. People are usually better. If they're not back yet, I think there's a problem. You got a problem probably in the hallway, guys. Sure, security sees it, and you just call and make sure.
And you got that over there.
Should have given bond.
Yeah, I'm so sorry. Yeah.
She brings him in, just throw it in the box over here, or cover, or put it where. Hey, lady, what's your name? What? Why were you causing a disruption in the court and then
I
didn't
was
come
talking to
back?
my mom's lawyer, and he stood up. I wasn't talking to him. I didn't say nothing to him. I was talking.
Why didn't you then stop when I told you to stop?
This exchange is crucial self-defense. Without the other party having a weapon, that's a steep uphill climb. The judge isn't deciding guilt, but they are testing credibility. And when the answer is there was no actual weapon, you can almost feel the bond argument slipping away.
I apologize.
That doesn't work.
Your Honor,
You want to be represented by counsel, man, because you disrupted these entire proceedings. You want an attorney?
Yeah.
PD can handle this, I think. She can go back into custody. I'm going to take a brief recess and then I'll bring her back out.
Morning, I'm Mike Getty, Assistant Public Defender on behalf of the respondent, defendant.
Yes, she would be responding. Your name, ma'am?
Hoya Jones.
Ma'am, you know why I held you?
Yes.
Tell me what your thought is on why I held you.
So I disrupted your courtroom.
Yeah. Disrupted the courtroom. And when I asked you to come back, try to figure out what was going on with you, you just kept continuing to walk. Why'd you do that?
And here's the turning point nobody expected. The bond is denied and immediately. The emotional pressure spills into chaos. This is what people don't realize about courtrooms. Tension doesn't disappear when the ruling drops sometimes. That's when things explode.
My mind was like blank. That's my first time seeing my mom since, and it was just like a lot. It was a little too much. It was my first time seeing my mom since this incident happened. And I was trying to ask the lawyer something. I was so focused on her answering my question. I couldn't even really like hear anything else. I was just too upset. But I'm not using that as an excuse. I take accountability. I was wrong for that. But it,
Your mom's coming back in a week or two, right?
Correct, John.
Huh?
That's correct.
So is it that you can't, in seeing all of that, can't keep yourself composed in the courtroom?
no, I thought it was an understanding before my mom got up here about mentioning her injuries, and nothing was mentioned about that.
Okay.
And that's what I was asking her.
You need to let the attorneys do their job. Okay?
Mhm.
You have an issue to the extent that they'll even talk to you. If you have an issue with them, then you deal with that outside of the courtroom. So should I banish you from coming into this courtroom again?
No.
You think you can conduct yourself?
Yeah. Yes.
Young lady, I'm going to give you another chance. If you come back in here and act the way you did, I'm going to guarantee you this. You'll be locked up like you are now, but I'm not letting you out. Are we clear?
Yeah. I have no problem with that. I'm not a disrespectful person.
You're not what?
I said I have no problem with that. I'm not a disrespectful person. I wasn't
Oh,
raised
you were today.
I was today, but I'm not
Not only
every
to
day.
whoever you were talking to, but also to me, and I hadn't done anything. Right?
Mm-hmm.
So just check yourself next time before you come in here. All right, we can move it. Let it go.
Thank you.
Thank you. Court is standing recess, and I guess we'll come back and do our 2 o'clock block.